High Court Criminal Division in Kampala, presided over by Judge Isaac Mwata, has begun hearing of the murder case against Henry Katanga, widow of Henry Katanga, her daughters, a medical practitioner, and a shamba boy Charis. Henry Katanga, who appeared in court on crutches with the help of prison wardens, was the first to be read with a charge of murdering her husband Henry Katanga, to which she pleaded not guilty to.
For ammend judge at all. So the rest I'm going to be reading to the document in English language.
So count by count, please.
So count number one.
Yes.
Is the matter contrary to section 188 and 189 of the Penal Code Act, Cap 120. The particulars of the offense.
Her two daughters, Martha Nkwanza and Patricia Kakwanza, were charged with destroying valuable evidence, while George Amanyire, medical practitioner, and Otai Charis, a shamba boy, were charged with being accessories after the murder.
Nkwanzi Martha Katanga, count 2, destroying evidence contrary to section 102 of the Penal Code Act, Cap 120. The particulars are that Kakwanzi Patricia and Nkwanzi Martha Katanga on the second day of November 2023 at Mbuya Chwa 2 Road, Nakawa Division, Kampala, capital city, knowing that diverse things at the scene of crime may be required in evidence in a judicial proceeding, removed, destroyed, rendered them illegible and incapable of identification with intent thereby to prevent them from being used in evidence. That is count 2 in respect of those people I read above.
Yeah,
that is Kakwanzi Patricia, Martha Katanga.
Do you understand? Is it true? They are not neutral. But the second count for H153. Next.
This is now count 3. It is in respect of Otai Charis and the Amanyire George. The offense is being accessories after the fact of murder. This is contrary to section 393, subsection 1. And in section 394 of the Penal Code Act, Cap 120. The particulars are that you, Otai Charis, and Amanyire George, the second day of November 2023 at Mbuya Chwa 2 Road, Nakawa Division, Kampala, capital city, Henry Katanga, Nkwanzi Patricia, and Nkwanzi Martha Katanga, who were their knowledge liable of an offense in order to enable them escape punishment.
Prosecution led by Samari Wakoli asked court for leave to allow them to amend the charge sheet. Prosecution requested to amend the charge sheet, seeking the accused, Martha Nkwanza, Patricia Kakwanza, George Amanyire and Otai Charis, to be charged with destroying valuable evidence and being accessories after the murder of Henry Katanga.
Whether to include on count 2. To include F4 and F5, and also to include the items and things that were destroyed. And for count 3, and for count 3, my Lord, to we have amended to include F2 and F3, and also to provide clarity in accordance to section 393, and also to correct to section 393 of the Penal Code, and to correct section 206 that provides for punishment.
Section 206.
Therefore, pray that he is therefore taken now on counts 2 and 3 afresh.
Let's just go to over.
Defense, however, objected to their prayers on grounds that their clients can't be charged with fresh offences, for which they were not committed to High Court.
It says you can amend charges every time, even to include people who never charged. But that is preposterous. If you bring a person who has never charged just before judgment, can you amend the charge sheet to include that person? Who has not attended the trial, who has not? Can you do that? Number 2. And that is being oblivious to the dictate of causing injustice, prejudice. Number 2, whatever is in the indictment for other people, whatever facts are disclosed for other people, that has nothing to do with the person who was not charged and committed for trial. Because you will not be bothered to prepare for a defense of a non-existing charge and facts which do not concern him or her. So it's not enough to say that the court knows. I, as an accused, must know it, and they are properly applied, so that I can prepare my defense. This did not happen in this particular case. You can amend, do the kind of things you have admitted you can do. You can't just put someone else and bring a person on trial before your lordship, who was not committed for this session.
Supplement on my senior colleagues' arguments. My supplement will be very brief. My Lord, I will start with section 50, subsection 2, which my learned colleagues, counsel for the prosecution, is relying on. My Lord, in that provision, my Lord, there is an exception. There is an exception, my Lord, which provides that there shall be no alteration to an indictment. There is an exception, my Lord. Alteration to an indictment, except that no alteration to an indictment shall be permitted by the court. By the court to charge the accused person with an offense which an opinion of the court is not disclosed by the evidence set out. In the summary of evidence. My Lord, that provision has been a subject of case interpretation by your learned colleague, the case of Uganda versus Biansi. My Lord, this is a criminal session session number 280 of 2014. And in summary, my Lord, that case states that no amendment or alteration can be permitted which would be prejudicial, to an accused person. My Lord, like my senior colleague has stated, the fact that the accused persons were not committed on these offenses, for which the prosecution seeks to introduce at this stage, it would be wrong, my Lord, to permit such an amendment stroke alteration. My Lord, what the courts permit such an amendment or alteration. My Lord, in that case again of Biansi, my Lord, what the courts permit, my Lord, are defects that do not go to the root of the offense. In other words, like my learned colleague has stated, making changes to the charges, provided it does not including new accused persons there. So my Lord would pray that amendment or alteration that my colleagues seek,
You don't include
making or adding new persons to those charges or counts. To that extent, my Lord would pray that
This court, my Lord, to order for an alteration if the indictment is defective, and this happens at any stage. My Lord, this happens at any stage, and the merits of this case require so. My Lord, there is no injustice that will be occasioned to the accused persons, because trial has not even started. We are just yet to start trial. Secondly, my Lord, I'm sorry, secondly, my Lord, the exception that is read, the exception is if the evidence is not disclosed in the summary. My Lord, if the evidence is not disclosed in the summary, my Lord, the summary that is already on court record, that the accused persons are also privy to, the evidence is included in paragraphs 23 and 24 of the summary of the case, which we filed
in paragraph
23 and 24 of the summary of the case, which the accused persons were all privy to. Which the accused persons were all privy to almost a year ago. My Lord, it will meet the ends of justice if this amendment is done. And we pray that there is no injustice that will be occasioned and that plea is taken. Mr. President.
In the same court, defense asked court to allow Henry Katanga proceed with the hearing of the case while in prison via video conferencing due to her unhealth status.
That the DPP was asking for an amendment to amend the charge sheet and charge people almost afresh. And we objected, and the court will give us a decision tomorrow. So that's basically what happened. And then when they give us a decision, we can continue. The reason we are objecting is that you have had to charge people for a very long time. You could have changed it, and now the charge sheet are defective. So you can't amend something that is dead. You can't resurrect a dead charge sheet. It is defective. That's our reason for that objection. So we'll have a decision tomorrow of court, and then we will pick it up from there.
Why does your client want to hear?
Okay, our client, as you see, the reason she wants to Zoom is that she has mobility issues, as you can see. Because of the repeated hitting to the head, she has what they call vertigo. When she stands, she spins. So that's why ideally, you know, Mori was savagely attacked on the 2nd of November. She's got to go over 5 surgeries to correct the attack on her head. When we begin the trial, you will see what happened. You will see that nearly 99% of the blood in their bedroom is her blood. Therefore, somebody who has lost nearly 70% of her blood, losing so much, the doctors will explain when the time comes. So that's when she stands, she rotates. So that's why she has problems moving. And here, because we have no ramp for a wheelchair, it has to be carried down the cell up here. So that is inconvenience. So she can appear on Zoom. No, it won't affect at all. Not at all.
Judge Isaac Muwata said tomorrow, 3rd July 2024, to deliver a ruling. Court extended the bail for the 4 accused persons and further remanded Henry Katanga to Luzira Government Prison.